Hi, welcome back to my channel. Please like, comment, and subscribe. 5 common maritime worker accidents that perils of working within the industry on a vessel are high, even if maritime employers are careful. As the CDC reports, marine transportation workers face a variety of unique hazards. These include, first, physical hazards like noise levels, vibration, ultraviolet light exposure, line handling, heavy lifting, slippery surfaces, steep ladders, and narrow passageway, which are exacerbated by weather conditions. Chemical hazards such as exposure to chemical cargoes, fuel cleanser, and diesel exhaust. Biological hazard that may come from the transmission of contagious disease between co-workers all working in a confined space aboard a vessel for days at a time, as well as travel-related infections. Together, these three obvious hazards, coupled with more subtle situations like fatigue, low job control, circadian rhythm disruption, and even social isolation can contribute to the reason why fatal injuries among maritime employees are 6 times higher than all other U.S. workers. These situations are also what contributes to common accidents that usually take place on the job. First, fishing-related accidents. Working long hours in commercial fisheries leads to fatigue, which results in imprecision during work. This, on top of external conditions such as terrible weather and shaky movement of the vessel, is the reason why 50% of maritime worker accidents involve commercial fishing. Second, injury due to inadequate training. The worker cannot carry out a specific task using tools and equipment while in the vessel due to a lack of proper skill or technique. It is the responsibility of an employer to ensure that they provide adequate training or hire individuals who show certification or qualification within a particular area. Third, worn out or substandard equipment. If the equipment used on the vessel is old and hasn't been replaced yet, it carries the risk of causing an accident that can injure people, no matter how expertly the maritime worker handles it or what safety measures they try to employ. The maintenance of work equipment is the responsibility of an employer. Fourth, slipping and falling aboard a vessel. Because of the vessel's erratic movement while on water, there is a good chance that maritime workers may slip or fall, leading to injuries. There is also a chance that an injured seaman may fall into the sea or get caught between vessels while leading the cargo. This is the trickiest of all injury claims because it requires putting other people at risk to save the trapped or overboard worker. Fifth, burns maritime workers stationed in the vessel's engine room are prone to coming in contact with hot oil and harmful chemicals. Maritime injuries caused by accident. The severity of injury claims within the industry depends on the accident's impact and where an injured seaman sustained that injury. Regardless of whether negligence is at play or not, the common work injuries employees face include head injuries to the head area are prevalent among maritime workers. Even if the injury sustained seems major, it is best to consult your physician first to ensure that everything is okay. If you plan to pursue further compensation as is within your rights, you will also need proof of these visits to help you build a case. The next is limbs. From operating safety equipment to hauling heavy cargo, it is possible to injure one's limbs during work. Slip and falls while on board a vessel are also common sources of broken limbs. Depending on the situation, uninjured seamen may also experience injuries serious enough to require amputation. Shoulder. Overexertion and poor form then exerting force are the main causes of shoulder injuries. There is also risk of incurring other injuries ranging from sprains, bursitis, dislocations, and others. There are training options available for individuals working within the industry that can help mitigate exertion-related injuries. For crucial types of maritime compensation for injured workers, there is a difference among maritime workers' company. Their occupation dictates the right they have, which affects the laws governing them. In the case of injury and accidents, there are specific laws that dictate how maritime workers can access and apply for worker compensation. First, General Maritime Law. This law requires employers to provide maintenance and cure to an injured worker. They must offer a room and board or maintenance and shoulder the medical bill or cure of the workers until she or he fully reaches maximum medical improvement. The employers must also pay for these living expenses, which include but are not limited to food, mortgage payments, and insurance. In this case, maximum medical improvement doesn't mean that workers need to heal from the injury fully. It merely refers to the point at which further care no longer improves his or her condition. Even if employers are not at fault for the worker's injury, they are still required to follow the law and provide the benefits above. It is not workers' compensation, but it's close. Second, Jones Act. The Jones Act is more serious and allows maritime workers to sue their employers for negligence during work that caused the vessel accidents and the resulting injury. The Jones Act covers seamen knowing as masters or crew members of a vessel on navigable water. According to the Department of Labor, seamen's main objective is to fulfill the vessel's purpose. Their duty does not involve functions of navigation and transportation. To collect their Jones Act compensation, the injury must have taken place on and was caused by a vessel on navigable waters. This means that the vessel has the ability to float and move under its own power. The vessel must also be on the water and not out of it or on dry dock. Finally, it does not have to be moving or at sea when the injury took place. Regarding navigable waters, the Jones Act applies to other water bodies such as lakes and rivers used for commerce purposes. Also, the seamen need to spend at least 30% of their time working in the vessel to be eligible for compensation. Proving the negligence of the employers is less challenging compared to other personal injury cases. The worker only needs to prove that the employee's failure to improve the working conditions caused the injury. There's no need for the burden or proof when it comes to this type of negligence damages. Thank you so much for watching. Don't forget to like, comment, and subscribe.